Good morning, good afternoon, and good evening, depending on the time zone in which you're watching us. Welcome to this event hosted by Delos Dispute Resolution. My name is Thomas Granier. I'm a lawyer practicing arbitration in Paris at Enka, and I'm very happy to be here today in my capacity as co-editor of the Delos Guide to Arbitration Places. As many of you know, Delos Dispute Resolution is a very dynamic arbitral institution, which is chaired by my colleague and friend, Hafez Virjee. It's not only an arbitral institution, but it's also a knowledge sharing platform. And in addition to the numerous events that Delos is hosting, you will find on its website the Delos Guide to Arbitration Places, which provides online practical overview of arbitration laws in nearly 60 jurisdictions, and that's been made possible thanks to the hard work of the law firms and reviewers that have participated in the preparation of the first edition of this guide, and we're preparing the second edition, which will be published in 2021 under the chairmanship of Professor Maxi Scherer and Professor Joongi Kim, our two panelists today. And today's discussion will focus on the law governing the arbitration agreement. And as we will see, this issue has been the basis of numerous and complex satellite litigations in relation to arbitrations. And some of you may wonder why. That's because a number of questions, including questions of jurisdiction, depend on the law governing the arbitration agreement. It's therefore not surprising that after having been decided by an arbitral tribunal, you find the same question before domestic courts, either at the place of the arbitration or in the various jurisdictions where enforcement is sought. And because approaches to this issue vary from one jurisdiction to another, and sometimes from one judge to another within the same jurisdiction, it's been a source of uncertainty for parties and practitioners over at least the past decade. And as the Supreme Court in Enka versus Chubb, the starting point of our discussion today, the Supreme Court of United Kingdom has stated, taking on the words of the Court of Appeal in the same case, time has come to seek to impose some order and clarity in this area of the law. So, clarity or confusion? That's the question which our panelists are going to answer. And today I'm very honored to have both co-chairs of the Delos Guide to Arbitration Places to talk about this highly technical topic. None of them needs any introduction. Nevertheless, I would like to say a few words about them before leaving the floor to them. So we have Professor Maxi Scherer, who is a professor of law at Queen Mary University of London, where she holds the chair for international arbitration, dispute resolution, and energy law. She's also a special counsel at WilmerHale in London, and she's admitted to the Paris bar and a solicitor in England, which means that she has extensive experience in arbitral practice in both civil and common law system, with of course, a particular focus in the energy sector. And she has represented clients, has acted as expert, and she has sat as arbitrator in more than 100 arbitrations under most, including commercial investor state, under most major institutional rules with all the letters of the alphabet in different orders. She publishes extensively in the field of international arbitration, including recently the international arbitration and the COVID-19 revolution at Kluwer 2020. Professor Joongi Kim is a professor of law at Yonsei Law School in Seoul, Korea. His research focuses not only on international arbitration, but also on international trade and investment, corporate governance, and good governance. His famous treatise on international arbitration in Korea received the 11th Simdang International Trade and Business Research Award. He served as arbitrator under all of the most major institutional rules and in ad hoc arbitration, just as Maxi. And in 2019, he was named the International Arbitrator of the Year by KCAB International and the Korea Economic Daily, and he received the top 10 arbitrators in Asia Pacific Awards by the Bali International Arbitration and Mediation Center. And so we're very, very happy to have them today. And before leaving the floor, I would like to make one last comment. We will, of course, open the floor to questions. And if we want to submit them, please do not hesitate to do so via the Q&A box, and we will take as many questions as we can at the end. Now, without further ado, Maxi, Joongi, the floor is yours.
Thank you, Thomas. I think I have the pleasure of starting, and first of all, thanking you for the invitation and for the kind words of introduction. It's always a pleasure to be a part of the Delos events. And I can only second what Thomas just has said. We would be very keen on getting your views, getting your questions at the end of this session. So please do keep them coming. My actually quite complicated task at the beginning of this session is to present a short reminder of what the Enka versus Chubb decision actually decided. I think probably most of you will be familiar with the decision by now, but it is actually important to just remind us of a couple of points in the making of the decision before we starting analyzing them and asking the question about clarity or confusion. So just as a matter of factual background, there's very little that you need to know. This is a case about a fire that occurred in 2016 in a power plant in Russia, allegedly due to the fault of Enka, who was the subcontractor in that construction of the power plant. The contract between Enka on the one hand as subcontractor and the main contractor of the work is the contract that contains the arbitration agreement, and an arbitration agreement that provided for a seat in London. That same contract did not provide for any governing law provisions, neither of the contract itself nor of the arbitration agreement. And now a dispute arose between Enka on the one hand and Chubb, who is the insurer of the main contractor. Chubb, Russia, that is, started proceedings before the courts in Moscow, Russia, whereas Enka resisted those court proceedings and at the same time filed suit before the English High Court to seek an anti-suit injunction against proceedings in Russia and a declaration that there was a valid arbitration agreement in the contract between Enka and the main contractor. It's in that context that the question of the law governing the arbitration agreement arose before the English court. The Court of Appeal in the first before going to the Supreme Court, the Court of Appeal decided that the arbitration agreement was governed by English law, and it did so on the basis that the seat of the arbitration that the party has chosen was in England, and that was an implicit choice that the arbitration agreement was governed by English law. Now, the case came to the Supreme Court, and as you will be well aware, in October this year, the Supreme Court decided with a 3-2 majority to uphold the decision of the Court of Appeal. So the Supreme Court, at least in its majority, also found that English law governed the arbitration agreement. Importantly, though, it did so on a very different reasoning compared to the Court of Appeal. So where the Court of Appeal had found that English law applied as a matter of an implicit choice of law based on the seat of the arbitration, the Supreme Court actually said that there was no choice of law whatsoever, neither explicit nor implicit, and it came to the application of English law as a matter of the law with the closest connection. Now, this was for the majority. The majority also not only provided the actual outcome of the case, but as Thomas has reminded us in the introduction, said, we're going to try to get some clarity in here. And it gave some directions and criteria as to how the arbitration agreement, the law governing the arbitration agreement should be determined. And these are really, this is the nitty-gritty of the decision that has sparked so much comments and analysis. I'm going to try to be as pedagogical as possible, but it is not quite easy. The first hypothesis is the easy one. The first hypothesis is if the parties have explicitly chosen the law governing the arbitration agreement. It happens rarely, but if it does so, everyone agrees that almost everyone agrees that the law chosen by the parties specifically for the arbitration agreement should apply. The second hypothesis is the hypothesis that actually is the most likely in practice, in real life. And that is that the parties have chosen the law governing the contract, but they have not chosen the law governing the arbitration agreement. So there's a specific clause in the contract says English law, whatever law applies to that contract, but the parties have not said anything in particular about the arbitration agreement. And it's in that hypothesis, the most likely in practice, that the Supreme Court, the majority, said that the express choice of the law governing the contract, the lex contractus, is deemed to be an implicit choice of law also for the arbitration agreement contained therein. Now, concretely, let me give you an example. If the parties say, have a contract that, and they say it's governed by English law, but at the same time say that the seat of the arbitration, say, is in Sweden, the law of the arbitration agreement is deemed to be English law because of that specific choice of law in the contract. And the fact that the parties have chosen the seat of the arbitration elsewhere, according to the majority of the Supreme Court, does not displace the presumption of an implicit choice of law. So far, so good. But here comes where it gets more complicated. There are actually two exceptions to this principle. The first exception is that if the law chosen by the parties, the lex contractus, is likely to invalidate the arbitration agreement, then another law should apply to the arbitration agreement. So that's what usually or typically is called the validation principle. The other exception, and this is where I ask you to fasten your seatbelt because that's where it gets really rocky, is that if the law of the seat of the arbitration indicates, and I'm actually quoting here, indicates where an arbitration is subject to that law, that the arbitration will also be treated as governed by that law. Now, let's try to unpack that. Let's go back to the previous example that I've just given you, that the parties have actually entered into a contract, that contract is governed by English law and the seat of the arbitration is Sweden. So the principle would be that English law as the lex contractus is also the law of governing the arbitration agreement as an implicit choice. But here comes the exception. If Swedish law as the law of the seat indicates that according to Swedish law, once you have chosen the law in Sweden, it actually applies also to the arbitration, then Swedish law might apply to the arbitration agreement. Now, if you find that complicated, I'm all with you. It's actually quite complicated. Now, the third hypothesis, this was only within the second hypothesis. The third hypothesis, and this is where it becomes easier, is that the parties have not chosen whatever law whatsoever, not explicitly, not implicitly. And here, the majority of the Supreme Court said, you need to find the law with the closest connection, and that is the law of the seat of the arbitration. Remember, that was actually the basis according to which the Supreme Court then actually found in Enka that English law applied to the specific case at hand. Now, there is, of course, a dissent as well. I told you this was a 3-2 decision, and it was actually a very strong dissent by two judges, Lord Sales and Lord Burroughs. And it's important also to keep in mind what they had to say. They actually disagreed with the majority and thought that Russian law should apply to the arbitration agreement. And they did so on the basis that they said there was an implicit choice of law, the parties governing the contract, and that implicit law, choice of law, also meant that there was an implicit choice of law regarding the arbitration agreement in favor of Russian law. So they disagreed on the result, but they also importantly disagreed on the analysis and the steps I've just outlined that the Supreme Court has given to clarify the question, because they said that the closest connection, if there is no choice, should not be in favor of the seat, but should typically be in favor of the law governing the contract. So we will discuss all of these points in detail during our session. And before I hand over to Joongi, the only preliminary remark I would like to make is to say that these are three very fundamentally different approaches. The Court of Appeal said law of English law because there is an implicit choice of law because of the seat. The majority of the Supreme Court says there was no choice of law and therefore we apply English law as the seat, but as the law of the closest connection. And third, the minority who said, yes, 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 there was a choice of law. It was an implicit choice of law in the contract and therefore for the arbitration agreement in favor of Russian law. So at a minimum, going back to our question of clarity or confusion, one can say that there was indeed quite a bit of need for clarity because these three different approaches are quite confusing. Whether or not the Supreme Court has managed to get some clarity in here, I think will be the purpose of our discussion today. And with that, I'll hand over to Joongi for his comments on the decision first.
Thank you, Maxi. Greetings from Korea. I think based on Maxi's crystal clear presentation, we now completely understand all the issues and everything should be very evident by now. It is a complex ball of wax. And to some degree, I think the Supreme Court has brought clarity to the UK position. Maxi clearly explained the ball of wax, but it's so complicated. It is so complicated. So just if we try to analyze this case, and there's lots of angles to pick at this, of course, one thing is it's a 3-2 decision, that's a very fine line. And one would think where that seesaw is going to go. Could it tip the other way? And then in that case, what do we think about the dissenting opinion? And the dissenting opinion is actually a very interesting read in its own. Their finding on that the Russian law should apply also has some interesting points. And of course, the second point, as Max stressed, that Russian law is the law with the closest connection, is also a very powerful point that the dissent raised, which actually kind of, from one perspective, maybe goes very far. And so the two extremes would be kind of the Court of Appeals decision, and then the dissenting opinion, and then you have the majority opinion kind of in the middle. So that's one thing I was thinking about. The other thing is, at the end of the day, it provides clarity, hopefully, for us. But I was thinking, what does this do for London? And the tension is, as Maxi, explained, and as we all know, in practice, parties will tend to choose a governing law for the agreement, and they'll choose a seat, but how often are they going to choose a law governing the arbitration agreement? Some institutions are trying to promote them to do this, and we hope more arbitration experts will get involved so that they can this issue can be addressed and we won't have to talk about this anymore. But in reality, at the end of the day, if we have this is your typical contract for most contracts, then what does this do? So in that situation, unless that exception applies that Maxi was talking about, the exception that the seat specifies specifically that the law of the seat should apply in terms of the law of the interpret the arbitration agreement, then you have to go through this complex analysis, and based on the Enka decision, actually it'll tip the other way, and it'll be the law of the governing contract. But is that really what the parties want? If you choose London as a seat, I would think that a lot of sophisticated parties would actually want English law to apply. That's one thing. So, and of course, then we have some interesting countries, like notably, of course, Scotland, well, not country, jurisdiction, and Sweden, of course, that have adopted this type of law, where they've clarified that if you're seated in Edinburgh or if you're seated in Stockholm, and we have this and the governing laws elsewhere, then actually the law of the seat, Stockholm or Edinburgh, would apply. And I think that the question I'm wondering, of course, is that going to spread more? Are there going to be more countries doing that? So that's another thing I thought would be very interesting to think about. The other thing about the case is it's a very, very thorough case, very, very detailed analysis. It's a fascinating read if you're an arbitration nerd. It goes into lots of comparative analysis, leading treatises, and that type of analysis, you don't find that often in Supreme Court decisions around the world. And I think that's also something very notable and commendable for the Supreme Court. Why don't I pause there?
Tom, I don't know if you want me to comment quickly on what Joongi has said, and I know seen there already a couple of questions in the chat, but maybe just bouncing from what Joongi has said, I totally agree that the probably major criticism I would put to the solution of the Supreme Court, that it is becoming very complicated. And if you put yourself in the shoes of a judge who is trying to ascertain what the law governing of the arbitration agreement is, it becomes a very complicated analysis. Take a fairly simple example where, say, the parties have chosen, the law of Qatar as the law governing the contract, and a seat in Switzerland. And it might well be that such a case is before the English court, for instance, as you know, at the enforcement stage. Now, in order to ascertain the validity of the the governing law of the arbitration agreement, the judge, as a principle, would apply Qatari law, but needs to actually make an inquiry into Qatari law to check whether maybe Qatari law might invalidate the arbitration agreement. And if it does, if it's likely that it does, might apply a different law. It needs also to have an inquiry into the law of Switzerland as the law of the seat of the arbitration, to check what Joongi has just described, whether under Swiss law there isn't a principle that by choosing the seat in Switzerland, the arbitration itself is governed by Swiss law. So before even determining the law governing the arbitration agreement, the judge needs to ascertain two different foreign laws, the content of two different foreign laws. And it's only after that that he or she can determine the governing law. And it strikes me that that is a fairly complicated mechanism. And I don't mind to be disrespectful with any judge, particularly not the English judges, who are, very well equipped when it comes to making inquiries into foreign law. But it is error prone. We've seen this in Dalla, where the Supreme Court, after a very long analysis of French law, came to a result that the French courts later on said that they didn't agree with, applying the same principles, that is, of French law principles. And so applying a foreign law on the question of whether or not an arbitration agreement is valid, et cetera, is error prone in itself. And here, you need to make that analysis before even getting to what the governing law is. And that strikes me as complicated. The other comment I would make, and this is maybe stepping back a little bit from the decision itself, is that we always talk about the law governing the arbitration agreement. And it strikes me that the answer is not necessarily that there is only one law governing the arbitration agreement. It probably depends on A, the question that you ask, and B, when you ask it. Let me try to be a bit clearer on that. The question that you ask might be different, and the governing law might be different. For instance, if you look at the validity of the arbitration agreement or the effects of the arbitration agreement and whether or not it can be extended to non-signatories. Even the validity of the arbitration agreement might be, you might sort of have a sub-distinction between the formal validity and the substantive validity. This is a very well-known distinction that exists, for instance, in German and Swiss law. So there isn't one question of the law governing the arbitration agreement. For those who are readers of Gary Bourne's treatise, he has actually identified no less than 13 different questions relating to the arbitration agreement that could potentially be governed by different laws in the same context regarding the same arbitration agreement, that is. And then it might also depend on when a specific question is asked. For instance, the question of the validity of the arbitration agreement might be asked at the outset, before the arbitral tribunal is even constituted. It might be asked during the arbitration in front of the arbitral tribunal, for instance, to determine whether or not it has jurisdiction. And the question may rise again in the post-award phase in enforcement or set-aside proceedings. And while in an ideal world, you would want to have the same law governing the arbitration agreement and the question in all of these different time lines or time dates, that might not necessarily work out. If you look at, for instance, Article 5.1a of the New York Convention, it says very clearly that at the recognition and enforcement stage, if there is no choice of law governing the arbitration agreement, it should be the law where the award is made, which is typically understood as the law of the seat. Now, that works well at the enforcement stage. It does not work so well at the outset of the arbitration, where the tribunal might not have been constituted, the parties might not have even chosen a law of the seat of the arbitration, and therefore no one knows what the seat of the arbitration is or what the law of the seat of the arbitration is. So that is just to say that the idea that there would be one governing law of the arbitration agreement is in and of itself, I think, a bit of a false question. And there is some inherent, I wouldn't say confusion, but difficulty because of these multiple factors, time-wise, and depending on the question that you ask. So I'll stop here, and I don't know if you already have some questions or if Joongi wants to come back on those points.
Joongi, do you have some rebuttal points, or would you like to leave the floor to questions?
I'll just add one small comment. I can say quite confidently, and most unfortunately, among the probably 1,000 judges in Korea, which was the best and the brightest, I'm quite sure that none of them are experts in Qatari law and Swiss law at the same time.
Thank you very much. So that highlights the complexity that not only clients, but we as arbitration practitioners, but also judges, the difficult task that they have in ascertaining questions that are put to them in respect of the law governing the arbitration agreement. And it is perhaps not a surprise that we already have quite a number of questions. The first one being from Sadia Bhatti, who asks, and I'm quoting her because it's a deliberately provocative question, not to be overly skeptical, but if one looks at the UK court decisions in Enka and the English decisions in Kebab and Sul America, it seems the common thread to all of these decisions is that the Supreme Court will decide English law is applicable, whether through the law applicable to the arbitration agreement or the seat of arbitration. And that prompts another provocative question from me, which is, we've seen how complicated all this is, even for experienced arbitration practitioners. And Sadia's question goes to the point that, is it not slightly artificial, given that at the end, we're gonna apply the law of the jurisdiction where annulment is sought or enforcement is sought? Should we just drop the guessing part about which law the parties wanted to govern the arbitration agreement and just adopt the French approach, which disregards this point? Two questions.
So same Thomas, thing. just to clarify, she added a kind of a clarification in the second. So you might want to read that one too.
Is the French approach clearer in your view? Or that's indeed another question. So I'm happy to give my views, but I'm passing on the baton to Maxi and Joongi in respect of the first part of the question.
I'm happy to start just top of my head, and then Joongi, you can give more thorough and more detailed analysis. So just on the top of my head, to these 2 points, let me maybe start with Thomas, your question first, and then I go back to Sadia's question. And the first question about the French approach, maybe just for those who are not well aware of the French approach, the idea is to say we don't apply any domestic national law to the question of the law governing the arbitration agreement. We just ascertain whether or not the parties had an intent to arbitrate. And the French say this is on the basis of principles of international law, and the only limit really is public policy. So all you need to check is whether the parties had an intent to arbitrate, and you don't do that with reference to a particular law. As far as I'm aware, it's the only jurisdiction where that type of reasoning is made, and it has the advantage of skipping this whole question of the applicable law, that's for sure. But if you want to be a bit cynical about it, it's only the French case law that says so. So unless you find yourself in front of a French judge, no one else will apply that, or you need to get to French case law by conflicts of law analysis. So it only skips the question for the French themselves, but at the end of the day, it is a French solution, and therefore, in order to get to that solution, you need to decide whether or not the law of France, including these principles, is governing the arbitration agreement if you are somewhere else in the world. And this is exactly what has happened in Dala. In Dala, the Supreme Court in the UK said we are going to apply French principles. French principles, do this sort of non-national, international law principles of just looking at the intent. And they came to one solution and the French courts came to a different solution, but it does not guarantee harmony either. Now, regarding Sadia's provocative question, and I'm not quite sure whether there was actually a clarification in the subsequent comment, but because it's such a provocative question, I'd actually like to answer it. Maybe it's not what she wanted to ask, but I'll answer it anyway because it's a great question. One could say that there is a tendency by English courts to somehow always get to English law, be it through a lens of the law of the contract or the law of the seat. I think maybe more conceptually, the difference between what English judges do and what, for instance, a civil law judge would do in a particular case like this is they try to ascertain the will of the parties. They try to ascertain what the parties really wanted. And they do that in applying general principles of, the English judges, general principles of contract interpretation. And so the importance of an implicit choice of law is extremely broad. And it has been emphasized in particular by the dissent in the UK Supreme Court decision, but also the majority really, a lot of it turns around the question whether there is or not an implicit choice of law. Now, the civil law approach is more mechanical. It's not necessarily ascertaining the will of the parties in a particular case, but it is applying a conflicts of law rule. And while there is the concept of an implicit choice of law in civil law jurisdictions, it's only in a tiny, tiny, tiny margin of cases where there is actually an implicit choice of law. So a civil law judge will be much more mechanical. They will look at, is there a choice of law? Yes or no? And then if not, we do apply the fallback, and this could be either the seat or the law governing the contract. But it's not necessarily looking at the intent of the parties in a particular case. And that's why the solution might be sometimes a bit unjust, but at least it is more predictable than in some of the cases that we've seen where you need to take into account all these various, very complicated factors that hopefully get to the result that the parties had in mind in that particular case.
Just to add, since Maxi kindly gave me a little bit of time to think, just to clarify Sadia's additional comment, she said the above comment was sent too fast. The last sentence should be read as whether through reasoning that the law applicable to the arbitration agreement is a law governing the contract, the most connection test, or the law applicable to the seat of the arbitration. She wanted to clarify that. So I guess at the end of the day is I detect her being provocative. There's this kind of a slightly cynical tone that at the end of the day, they'll always reach result in English law. But I guess the ultimate test from that perspective would be if there's another case where the facts are reversed. For instance, if the governing law of the contract is somewhere else, and they decide ultimately that it's not English law, but it's, I don't know, Indonesian law that applies, then that would, I guess, dispel this kind of slightly cynical view. I would suggest that what she has here is a bit, I mean, I think the decision, it is methodical in its own way. And working through that, I mean, I don't know if they're not random things. There's a very specific order and priority that they have lined up. So in that regard, it is a predictable scheme in terms of the sequence. So I think that is actually clear. But I think the more interesting thing is, as Maxi highlighted earlier, in the process of determining what goes into that sequence, things can vary quite a bit and lead to lots of confusion. So the general process is kind of clear, but the result that can end up in can get confusing. I hopefully that will answer kind of.
And it's true. Thank you very much, Joongi. It's true that it can be confusing. There are some laws, as Maxi has highlighted, has pointed to, that have tried to correct, to help in that respect by providing for default provisions. There are also institutional rules that now provide for a default rule, such as Article 16.4 of the LCIA rules, that provides that the law applicable to the arbitration agreement shall be the law applicable at the seat of the arbitration, unless and to the extent that the parties have agreed in writing on the application of other laws. And this provision actually has given rise to questions from Jacob Griffin and Ole Jensen, whether or not arbitral institutions could not play a role in order to reinstate some clarity in this confusing area of law, to cite the Supreme Court. Are you aware if, for instance, institutions in Asia, Joongi, are currently considering perhaps introducing such revisions to their rules?
I'm not aware off the top of my head. The only thing that I do note is, of course, HKIC. What they do is they have a model clause, and they're very proud of this. That in their model arbitration clause, they suggest the parties should specify the law applicable for the arbitration agreement. And I think that's one of the few institutions that actually puts that in their model clause. But I don't think they've gone as far as LCIA and included in their rules. I think Jacob has raised an interesting point as to what Delos should do and whether they should follow the LCIA 16.4 rule that would clarify this.
Absolutely. One of the questions here is whether or not Delos will consider it. This provision does not yet exist, and I'm probably breaking up something here, but there will be a revision of the Delos rules fairly soon, and this is one of the points that is currently being considered, including in light of today's debate. Other questions? Another question.
Sorry, while you look at the other question, let me just add on the 16.4 LCIA rules. I mean, to a certain extent, one could argue that the Enka decision for at least LCIA arbitrations has basically become meaningless, because if you have an LCIA arbitration with a seat in London or a seat elsewhere, by the choice and party autonomy of the parties, you will have the law applicable to the arbitration agreement being the law of the seat. And so you don't even get to Enka. So it is really only if it's a ad hoc arbitration or an institutional other than the LCA and you get to the Enka rule. I think that's it's an important limitation to the scope and the application of the principles set out in Enka.
And following up on a point that we've touched upon when addressing the French approach, another question, which is that so at paragraph 55 to 58 of the majority's decision, Enka, is that these developments give the impression that the international view would be that an agreement on a choice of law to govern a contract should generally be construed as applying to an arbitration agreement set out in this contract. And do you think that this reflects the international view? That's if there is an international view.
Maxi, you want to take a stab or shall I go?
I'm happy. I was disconnected for just a second, so maybe I lost a bit of it. But I think if the question is an empirical one, as to whether the number goes in one side or another, I think it's a really tough question. To be honest, I've tried to actually do a world map and sort of get into, say, blue, all those who say it's the law of the seat, and in red, all those who say it's the law of the contract. But that exercise in and of itself is a bit flawed, because very often, like in Enka, it's not a one size fits all, a blue or red answer, but there can be some, sometimes blue, sometimes red, depends on blah, blah, blah kind of answers. And therefore, it becomes actually quite complicated to quantify the solution, whether one has the majority or not. So I would be hesitant to put my arm forward to be cut in one way or another. I think it's a hard question to quantify, and I've tried.
Yeah, I would suggest actually there's probably a lot more green, purple, and orange than we think there is.
It's true, and even within common law jurisdiction, judges, whether Singapore, Hong Kong, England, judges are not unanimous on the approach to follow in that respect. Even in Singapore, I mean, we have two contradicting or two new decisions nuancing each other within that have been rendered within a few years. So it's true that it would be difficult to determine. But
and also in civil law countries as well, there's a lot of division as well, and there's a lot of flux and unsettlement. So I don't know how they empirically derive the international view. I don't recall that they offered. I don't recall that they offered any like a detailed map that Maxi was looking for.
And then there are, of course, also countries like Switzerland who actually have the validation principle enshrined in the law. So it's not the law of the seed or the law of the contract, but it really very much depends on which one is more favorable to the validity of the arbitration agreement. So again, that would be in the sort of green, purple, or yellow category, as Joongi put it. And I think in that, Enka was very helpful to have at least positively, included the validation principle in the process of the various questions. There have been in the past references to the validation principle, but I think we've never had it so clearly enshrined in the process as in Enka. And I personally think that is a helpful addition. It's a helpful addition, but it's not an addition that will be, necessarily apply in all cases, because the validation principle in and of itself requires that you can say, yes, it's valid, or no, it's not valid. And for other questions, for instance, the scope of the arbitration agreement, whether or not it has effects vis-a-vis non-signatories, it's not a simple yes or no answer. So the validation principle actually gets to its limits here.
We have time for one or two further questions. But so we have a question from Stephen Lim, who noted the very categoric approach of the Supreme Court that said that English law and the interpretation of contracts as the law of the forum should be applied in construing the contract to determine whether there was an express or implied choice on the proper law of the arbitration agreement. And the question is, does the panel agree with this approach, or is it possible for arbitrators in particular to apply more general principles of construction? I don't know if the English judges would agree.
I know that Stephen is an expert on this. He wrote an excellent article on this, and he's actually quite critical of the English approach and believes it is actually out of tune and does not align properly with the New York Convention. And so hence his view that it's a very parochial approach. I tend to view his position has a lot of credence to it. And of course, one simple thing is, this closest connection thing. You don't have that in the New York Convention. Basically, you go straight to the seat. So I think there is room for the court in terms of trying to align itself closer to the New York Convention. There is room for more alignment.
I'm not 100% sure I would agree that the Enka decision is a parochial decision. And the reason I wouldn't say that is it's actually not in contradiction with the New York Convention. So the New York Convention says, on the one hand, if you have a choice of law specific to the arbitration agreement, you apply that law. And if you don't have any choice, you apply the law of the seat. But there is, of course, this middle ground, which is to say, well, you might have an implied choice of law. And this is the entire place of basically where Enka is, be it the majority or the minority, is to say, well, there could be an implied choice of law because of the law chosen in the contract, so says the majority, or the law of the law of the contract for both of them, actually. So the question really is the one of the implied choice of law, which sits in the middle between an express choice and the objective law under the New York Convention. So I wouldn't want to criticize the Supreme Court for being parochial in this particular situation, for somehow disregarding the New York Convention. And on the specific question whether arbitrators will find themselves to be bound to apply it, I think it's, as always, you of course need to keep an eye on the solution of the seat of the arbitration or possible enforcement forum, because you do want to render an enforceable award. So if you are asking yourself the question as arbitrator of your jurisdiction and therefore the validity of the arbitration agreement, and if the seat is in the UK or if it's a possible enforcement forum, you certainly will take into account the Enka process and criteria.
Thank you very much. I fear that we won't be able to take all the questions that we have, but I think we can. There are some comments and conclusion resulting from this discussion in respect, in particular, of Enka, and many of the commentators that we have seem to agree that Enka, with its split decision, probably added more confusion than clarity, and that at the end of the day, whether or not we believe that an approach of judges that would lead them to always apply the law of their forum, assuming that it's right, is perhaps that could be a concern, but that is perhaps safer, as Saadia has highlighted, given that sometimes judges, such as in Dala, as you pointed out, Maxi, might apply foreign law in a way that would actually surprise judges from that foreign law. And so, in a way, it's perhaps not that bad. What do you think about this conclusion?
Maxi, why don't you go ahead if you want?
I think I mentioned my view on this earlier, so I'm not going to, for the sake of time, not wanting to repeat it.
No, but that's probably we're now reaching the end of the session. So I will need to thank everyone, in particular our panelists. This was a very interesting discussion. And now perhaps for the closing words, we might be joined by Hafez Virjee, who is the president of Delos.
Thank you. This was a really interesting discussion. Echo. There we are. That was a very interesting discussion. Thank you all very much. Thank you as well for joining in the celebration of the GAP. As many of you know, and as Thomas introduced earlier, it's our flagship publication. It's one that's being used quite a lot, and we're fortunate to have our co-chairs with us here today. It's a long haul project, and we've got the plan is to publish the second edition next year. But for today, this event brings to a close our symposium, which was the first gathering of our working group. And if you consider a publication with over 60 law firms, or some 60 law firms and some 70 reviewers, it's quite a sizable group. So for us, this was quite a milestone to bring everyone together. And thank you all for joining in for this occasion. So with that, we close the symposium. I don't know if anyone else wants to say a final word. Otherwise, we'll see you again soon.
Thank you, everyone.